Hello! And here I am. And I'm doing the intro right now while we're waiting for people to get in here. I'll give a little bit of background on me. For one thing, of like, why am I qualified to read these court documents to you and have an opinion about what's going on in the Barry Morphew case. And first off, I was one of the first people to report on this. I was boots on the ground. That's what drew my interest into the Barry Morphew case. Next, I'm highly educated, but I'm not an attorney, but I know my way around a law library, and I actually enjoy reading the law. So my background is actually in psychology. And I forgot to introduce myself. My name is Jules. And please like and subscribe if you like what you get here. And what I'm going to do is I will get into the Barry Morphew updates. I will talk about all these new documents that have now been made available to the public, and I'll be discussing what is going on in. Hey, Humanimal! Jack's here too. He says hi. Say hi.
Hi.
And anyway, I'll be getting into all the documents and what's going on, because one of the things that is going on is that next week, and hello Rainbow, all next week, Monday through Friday, 9 a.m. each day, is a motions hearing for Barry. The actual trial doesn't have a start date yet, but in the motions hearings, they're going to be going over the various motions that have been made, and oh boy, there have been a lot. And they basically set the groundwork for the trial, what's going to be admitted, what's not. All that happens during the motions hearings, and that's what's happening next week. We'll be discussing what they will be discussing during that, and I have a few orders that were filed. That's when the judge says, okay, this is how it's going to be. So we'll go over the orders, but also we're going to go on and read the people's responses. The people are the prosecution. They are, the state of Colorado and the district attorney's office, and they are who is prosecuting Barry. So whenever I say people, that's who I'm talking about, and Kelly is the district attorney. And when I say defendant, or if I more likely will be saying Jane, because Jane Fisher Byerliuson, or however you say her name, I'm just going to call her Jane. She is the most vocal, most visible attorney of Barry Morphew. Barry Morphew is going on trial for the murder of his wife, Suzanne Renee Mormon Morphew. And you will hear in some of these documents, they're going to refer to Morphew 1 and Morphew 2. This is what they're calling Morphew 2. This is the second time that there have been charges and a murder trial going for Barry Morphew. Morphew 1 was a bit of a debacle. It took place in the 11th Judicial, and there was a whole lot of mess with that, and we won't get into that right now, but I will say that Morphew 1, the evidence and everything from Morphew 1 is admissible in Morphew 2. Morphew 2 is being tried in the 12th Judicial. It's got a whole different set of prosecutors, a whole different set of eyes, and actually in Morphew 2, we have the addition of Suzanne's remains were found, so there's a lot more evidence in Morphew 2, and I guess we will just get into it now. And I'm going to write down for a second where this is, because for the replay crew, I'm going to try to put in timestamps so they know when stuff actually started. So, here we go. First off, the first order that was filed, I'll let you know about that one and that. Which pages are they? Okay. The first order is the one and only people's motion that has happened since the last time I updated you on all the files. And it's the fourth motion by the people, and the people did an unopposed motion for extension of time to file notice pursuant to Rule 404B. And it reads, in the court's case management order, the court provided the people with a deadline of June 15, 2026 to file the people's notice of intent to introduce evidence pursuant to Rule 404B. The people request a 1-week extension of that deadline to June 22nd, 2026. Then it wasn't objected to by the defense, and of course, the order was that it was granted by the judge. So we got that out of the way. And next, before I go to the order, I will go to D11 by the prosecution. And this is one of the ones that I was telling you I was looking forward to, because remember, and those of you that don't remember, in the last video about the files, I read the defense's motions and was saying, oh boy, I can't wait to see how Ann Kelly responds to these, because I was calling out that the defense, Jane, seemed to be filling the court with frivolous documents, trying to bog down the system and delay justice, and that I was like, I can't wait to see how the prosecution is going to respond. And I'm going to tell you, when I go through all these responses to you, they did not disappoint. Anyway, for D11, people's response to the defense motion for notice of the prosecution's intention to introduce any evidence or testimony under CRE 807. And it says, the defendant has requested that the people provide notice of their intent to introduce evidence pursuant to CRE 807. Advance notice of a party's intention to introduce evidence pursuant to this rule is required by the rule itself. The people have and will continue to comply with the requirements of Rule 807. The people filed a notice of intent to introduce evidence pursuant to CRE 807 on April 13, 2026. In that notice, the people indicated that the notice will likely be supplemented as trial preparation proceeds. The people anticipate that the admissibility of the statements proffered by the people pursuant to CRE 807 will be litigated at the motions hearing set for the week of July 6, 2026. The people may call witnesses to testify regarding the elements of admissibility required pursuant to the rule. The defendant suggests in his motion that any legal argument can be set forth without recitation of the evidence the prosecution seeks to admit. The people believe the defendant is suggesting that oral argument and the presentation of evidence in support of the admission of CRE 807 statements should be curtailed to avoid potential jury exposure to the evidence. The defendant provides no legal authority or the proposition that advocates should be limited to their advocacy, that advocates should be limited in their advocacy on a motions issue to avoid influencing the public who may be called to serve on a jury. No such authority exists. Rather, the court has made clear that the parties shall not make or disseminate an extrajudicial statement that the lawyer knows or reasonably should know will have a likelihood of prejudicing a criminal proceeding. The people have complied with that order. Moreover, Colorado courts consistently hold that proper voir dire of a jury panel is sufficient to overcome any suggestion of prejudice created by extensive media coverage. And then there's citations, which I won't bore you with, but it cites 3 or 4 other cases. Okay, that's their response to the interval. And then, of course, the order. The order has several pages of what the crazy Jane had filed with them motion for a notice of the prosecutor's intent to introduce any evidence or testimony under CRE 807. And of course, it's very simple. It says moot because this is proper procedure, introducing, the notice of the prosecution's intent to introduce evidence. That is procedure. That is the law. And the prosecution has been doing that all along, and so the judge said, that's moot. And it was a several-page document filed by Jane trying to say, you have to tell us if you're going to do any evidence. Well, of course they have to do that. Anyway, then we're going to read a couple more of the orders until we get to Order 19, which also had a response from Ann Kelly before we get to it. So, Order 13 was a proposed motion for notice of consumptive testing, where Jane had said that she wanted to make sure that whatever they tested, so will any new jury be informed of the previous trial and debacle? No, because that's not part of this trial. And they're getting that all ironed out during the motions hearing, what is going to be used at trial and what's not. So anyway, the defense asked that they be informed if there was going to be any consumptive testing. That's where a piece of evidence gets used up through the testing process, and that the prosecution needed to inform the defense about that. And of course, the prosecution didn't worry about that at all, because that also is pretty standard that they need to tell you, and so that the defense can also test. So anyway, granted. And 15, preservation of material for testing. They asked that when the prosecution tests something, they save some so that the defense can also test it, and that was granted. And of course, Jane took a couple pages to ask for that. And D18, request for in-person trial testimony of laboratory employees and technicians. And of course, that was ordered, and the prosecution wasn't worried about it because I think they probably wanted to have their witnesses be on the stand when they gave testimony. So, Jane wasted time filing that one also, several pages, saying that she wants the experts to be on the stand. And then we're going to get to an order for 19, and 19 had a response from wait for that one. Had a response from the prosecution. From the prosecution. So before I read the order, I will read the response. People's response to defendant's request for good faith witness list. The people are willing to exchange good faith witness lists with the defendants prior to trial. However, if the court orders only the people to provide one, it creates an unfair advantage for the defendant. Additionally, the people cannot provide an accurate list without knowing who the defendant has endorsed and who the defendant intends to call on his good faith witness list. For example, rulings regarding alternate suspects will impact the people's witness list significantly. Once analysis is done pursuant to People v. Elmar, the people's list will increase or decrease potentially by dozens of witnesses. Similarly, witnesses endorsed by the defendant will likely require the people to call additional witnesses. Therefore, the defendant's request for a good faith witness list 45 days before trial would serve the purposes outlined in their motion. The prosecution will not create a meaningful witness list and order until after the defendant is required to make his CR Crim P 16 disclosures 35 days before trial and after the people have an opportunity to reach out to any endorsed witnesses. Further, the defendant makes this request in the name of judicial efficiency and ability to prepare for trial, and these considerations also apply to the people. What would actually serve the interests in their motion more effectively is to exchange lists. The defendant has cited no case law or rule requiring the court to order the people to turn over a good faith witness list. Instead, his motion cites to only general principles of law. If the court orders only the people to provide a list, the defendant may choose not to exchange lists. The people are optimistic that if the court orders the parties to confer about an exchange of good faith witness lists, the people and counsel for defendant will be able to agree upon reasonable timing for such an exchange. This will serve all interests noted in the defendant's motion without conferring upon him an unfair advantage. For this reason, the people respectfully request an order that the parties confer in advance about an exchange of good faith witness lists, as is often done in trial management orders. For these reasons, the people object to the defendant's request to order the people to create and turn over a good faith witness list 45 days before trial, and respectfully request that the court order the people and the defense to confer as to an exchange of good faith witness lists. Good stuff, huh? And now the order. Proposed order regarding motions for good faith witness list. Granted with amendments. The prosecution and defense will each be required to submit a good faith list of witnesses who it will call at trial no later than the end of business on September 1st, 2026. And so, yeah, they have to, the defense is going to also have to produce their witness list. And the two parties will, the prosecution and the defense will exchange the good faith witness lists at that point, and then probably a couple days later is when they'll be made public, and we'll all know who's on the witness lists. And then we go through the rest of the orders because there's just this one. And it is notice the defense will require additional time in which to file motions, and the motion is granted in part. Any additional motions the defendant wishes me to hear July 6th through July 11th shall be filed no later than 4:30 p.m. on May 29th, 2026. Responses will be filed no later than 4:30 p.m. on June 22nd, 2026. And no replies to the responses to the additional motions will be considered. And that's, one of the specialties of Jane is she likes to put replies to the responses, because the responses are what the prosecution has to say after the defense makes a motion. Then the prosecution can say, well, that doesn't make sense because of, or we object to this, or, whatever that. And then the defense is allowed to respond again, but this is saying no more responses after that. Okay, that's enough is enough. No arguing. And please put a thumbs up or something if you like this, or even if you don't like it, please give me a thumbs up anyway. And now we'll get into some more of the stuff filed by the prosecution. These are the responses. This next one is a little bit long, and I'm also going to be reading some of them out of order because, defense 14 is what they're responding to here. But anyway, I'm going to save the meat and potatoes for the very end. There's one file in particular that I consider to be the meat and potatoes that I want to go over at the end. So, D14 says the defendant requests in his motion not only for material in the possession of law enforcement consistent. Oh, because this is the people's response to the defense's request that the that the prosecution gives them any information about impeaching any of the witnesses that they talk to. You know, not even ones that they're going to call, but just everyone that they talk to. And this is one of the things that has not been responded to by the courts yet. So this is one of the things that they're going to be discussing during these upcoming motions hearings. And I should tell you that basically everything that I'm talking about to you from this point forward, which, let me write down the time. For the replay crew, this is when we get into what all is going to be discussed at the motions hearing next week, is all these things. And so this first one is that the defense was asking that the prosecution give them impeaching information about everyone, you know, that they talk to in this case, not just who they're going to bring forward, but everyone they talk to. So anyway, the defendant requests in his motion not only for material in the possession of law enforcement consistent with the requirements of Rule 16, but demands that the court order the people to make inquiries to other sources available to the prosecution regarding impeachment information that is not and conceivably would not be within the purview of this criminal investigation. To the extent the defendant seeks material subject to disclosure pursuant to Rule 16, the people have and will continue to comply with their discovery obligations. You know, that Rule 16 is the law and is, you know, you have to disclose what you're going to use. The people specifically object to the defendant's demand that the people conduct additional investigation of other sources available to the prosecution, to the extent such a demand suggests that the people do additional investigations to seek out material beyond what is currently in the possession of law enforcement. The people further object to the defendant's demands contained in paragraph 7, sections J and K. Specifically, paragraph 7, section J requests any and all records of and information concerning prior psychiatric or psychological treatment, evaluation, or hospitalization of all prosecution witnesses. In paragraph 7, section K, the defendant seeks any and all information concerning drug and alcohol use, evaluations, or treatment of prosecution witnesses. First, the people do not possess any such material beyond what has already been discovered to the defendant. Second, the people have no legal authority to obtain such information and no legal basis to request such information, private information from witnesses. And then it cites a case, People v. Covington, from Colorado in 2001. And it says, the legislator created the physician-patient privilege to encourage patients to fully disclose medically relevant information to their physicians by reducing the possibility of humiliation or embarrassment through subsequent public disclosure. And so basically, HIPAA, they're saying, you know, we can't go investigating all of our witnesses and finding out whether any of them have mental health issues or whether any of them have ever been treated for mental health issues or whether any of them have ever had a substance abuse issue or what their habits are, etc. We can't do that. That's illegal. But that's what the defense was asking them to do. And people's response to defendant's motion for witness statements made to the prosecution. The defendant requests in his motion that the court order the people to comply with Rule 16. The people understand their obligations under Rule 16 and confirm compliance, subject to the protections afforded parties regarding disclosure of attorney work product. The people have no undisclosed material responsive to the defendant's motion. So, that was more busy work by Jane, where she's like saying, oh, disclose everything you have to disclose under Rule 16. And they're like, we have been...
They wanted mental health evaluations of the jury.
Yeah, they wanted mental health evaluations of the jury also. That's like,
Why?
Overreaching.
Why would she even attempt this?
I have no idea.
She's obviously smart enough.
Well, she's being paid by Barry, though, so she's got to do what Barry wants. She's,
This just makes her look like a clown.
Yeah.
So.
People's response to the defendant's motion to require notice of statements by the defendant that the prosecution seek to introduce at trial. And then we have a short piece that's the summary of response, and then a longer piece that's the relevant facts. And this is going to be fun. The defendant seeks to expand Colorado Rule of Evidence 106 to untenable links. CRE 106 protects litigants from the admission of party opponent statements that misrepresent what the declarant contemporaneously intended to convey. It is not a rule that permits the defendant to introduce his defense through out-of-court statements not subject to cross-examination by the people. Moreover, the defendant is not entitled to preview the people's case strategy by demanding to know what evidence the people intend to introduce under the guise of pre-litigating an evidentiary argument that lacks merit. Relevant facts. The defendant provided approximately 51 hours of recorded statements from May 10th, 2020 to his arrest on May 5th, 2021. There are 61 separate interactions with the defendant that are either recorded by video, audio, or both. These interactions occurred with various members of law enforcement from 3 separate police agencies. The subject matter of the recordings varied across interactions. All of these recordings have been provided to the defense in discovery. And then legal standard and argument. And 1, the rule of completeness does not require admissions of the many hours of the defendant's recorded interactions with law enforcement. Colorado Rule of Evidence 106 codified the common law rule that upon admission of a portion of an opponent's statement, the opponent was entitled to have the entirety of the statement introduced. If admitting only a portion of the statement would be misleading. People v. Doug Wittes, whatever, 1979, and People v. Maniac in 2016. If admitting only one part of a written or recorded statement would be unfair or misleading, the rule of completeness favors admission of other parts of the statement. CRE 106 provides that when a writing or recorded statement or part of is introduced by a party, an adverse party may require him at that time to introduce any other part of any other writing or recorded statement, which ought, in fairness, to be considered contemporary. Can't say the word with it. The rule does not, however, allow wholesale admissions of otherwise inadmissible hearsay. People v. Davis, 2008. The people may introduce all or a portion of several interviews the defendant had with police. The police do not intend to introduce all of the defendant's recorded statements. In doing so, the people intend to play the entirety of the portion of the defendant's recorded statement related to a specific topic. If that portion contains exculpatory words by the defendant, the people will introduce those words within the context of the topic introduced. That method is sufficient to avoid the errors raised in People v. Short, 2018, and People v. McLaughlin, 2023. In Short and McLaughlin, the trial court permitted the prosecutor to redact a portion of the defendant's sentence because it was self-serving, rendering the introduced statement clearly subject to misinterpretation. For example, the court in Short allowed the prosecutor to redact the bolded portion of the following statement by the defendant in a sex assault trial. Someone's abusing the victim, but it ain't me. In McLaughlin, the trial court permitted the prosecution to redact a portion of a DUI defendant's statements mid-conversation, with an officer leaving the jury with the impression that the defendant had no idea how his vehicle arrived at its location when his allegation that the actual driver left the scene was redacted from the recording. The key factor for the courts, in Short and McLaughlin, in determining whether CRE 106 applies was whether the admitted statement without the redacted portion is misleading or subject to a misimpression of what the speaker actually sought to convey. People v. Montoya, 2024. The defendant's suggestion here that he should be permitted to play all 61 of his separate interviews with police if the people introduce portions of his interviews is not consistent with Colorado law or CRE 106. The defendant's request is akin to the request rejected by the Court of Appeals in People v. Davis, 2008. In that case, the defendant was interviewed by police twice. In the first interview, the defendant made several self-serving statements denying the crime. In the second interview, the defendant made inculpatory, which means indicating his guilt, statements when asked essentially the same questions she was asked during the first interview. The people chose to play only the second interview. The defendant argued that the first interview was necessary to provide context for the second interview. The defendant argued that the first interview was for the second interview. The court rejected this argument and found that the first interview was not necessary to correct any misleading omissions created by the people's decision to play only one interview. In making this finding, the court also rejected the contention that the second interview was merely a continuation of the first, separated by the administration of a polygraph test. The court found that these were two separate, distinct interviews that the defendant's numerous interviews in this case. Finally, the court noted that the defendant had the right to, and did, choose to testify consistently with the statements she made during the first interview. Courts have consistently interpreted Rule 106 to apply to statements made in close proximity to or in the same conversation as the clarifying statement. For example, in People v. Maniac, the court upheld a trial court's decision to redact the recording of a defendant's phone calls to family members during a break from a police interview, rejecting the defendant's argument that those statements were part of the same interview and should be admitted. In both Short and McLaughlin, the court emphasized that admitting part of contemporaneous statement led to the unfair result. Let's see here. Barry must be very worried about who will be called as a witness. I wonder if he is concerned there is a witness from Moffat area on certain dates. Very interesting, and quite possible that he's worried about that. He should be worried about any of the witnesses because, you know why. Anyway, led to the unfair result. So far what I've been reading is basically stating that the defense is asking that if any part of Barry's interview, many interviews, he's had 61 interviews, and they're saying that if any part of his interview is played in court, they want to be able to play all 61 interviews. And this is stating that when they play a part of an interview, the defense can then play the rest of, or first part or whatever, they can play another part of that same interview about the statements that Barry is recorded saying, not all of the interviews. So, like, if they don't use all of the interviews, then the defense isn't allowed to use all of the interviews. They have to use the ones that are being used in court. So anyway.
61 interviews.
Yeah.
Barry just can't be quiet.
Anyway, the court in McLaughlin emphasized that the purpose of CRE 106 is to cure a misleading impression or to ensure that statements are presented in a way that reflects the statement accurately and fairly. The court further emphasized that the rule is not designed to allow a defendant to admit their own statements independently, or rather to cure misleading impressions. The Supreme Court's recent decision in People v. Montoya similarly emphasizes the application of CRE 106 to statements made in the same conversation or in close proximity to the misleading statement. In that case, the defendant initially refused chemical testing in a DUI investigation, and just 15 minutes later, the defendant recanted the refusal. The Supreme Court determined that redacting the recantation of the refusal so close in time to the initial refusal left the jury with a misleading impression of the defendant's intentions. Noting that the redacted statement here occurred minutes after the admitted statement, and the statements in McLaughlin were back to back. So, if Barry wants to argue about something he said in one interview, he has to only use what was said in that interview. He can't say, oh, but in a different interview I said I didn't do it. And anyway, where'd I go? Okay. The purpose of Rule 106 is to prevent a party from misleading a jury by excluding portions of a statement that would clarify or explain the part already received. People v. McKinley, 2025. People v. Weaver, 2024. And People v. De Jesus, the Court of Appeals, again focused on the fact that redacting a contemporaneous statement from a defendant disavowing knowledge of the contraband at issue left the jury with misleading impression that the defendant had at that moment no explanation for the contraband. And
do you think it's normal to use this much quoting of case law?
This is the prosecution. I believe it is normal because they're battling everything that was said by Jane in her request that this be done. So they're saying, okay, we've got a bunch of case law that shows that what Jane is saying is BS.
There it goes again with her wasting time.
Yeah. And so this is just basically responding to what Jane said.
Good clarification.
So anyway, the rule does not allow the defendant, as the defendant suggests here, self-serving interviews made weeks or months after an initial interview. Recorded out-of-court statements by the defendant are not necessary to cure a misimpression or are unrelated to the statements the people seek to introduce as statements by a party opponent, are inadmissible hearsay if the statement does not otherwise satisfy a hearsay rule exception. People v. Vanderpue. And so basically it sounds like Barry was wanting to, if they were going to use his admissions or anything like that he was giving in those police interviews, because we know a lot of, well, probably not even a lot. We know some of the things from the original preliminary that he did say. And he said some pretty stupid stuff.
He wanted that retracted.
And he wants to retract it. And first he tried to say it's not admissible. Then the court said it's admissible. So now he's saying if you use it, you gotta let me introduce other recordings. And then apparently one of the things from what I just read to you guys that they're citing, okay, you can't do this particular thing, and this particular thing is introducing another interview that didn't take place with law enforcement or anything, maybe took place in his lawyer's office or something, where he explained away whatever he said in the police interviews. And they're saying you can't do that. You can't go and say, oh, you know what, I didn't mean what I was saying back then or whatever. He has to only unless he's going to take the stand, he can't introduce a recording of him saying, oh, I didn't mean to say that.
Is he going to take the stand?
No word yet, but basically I think this is a way that he was trying to get out of taking the stand by trying to say, oh, can I introduce a recording of what I said to my attorneys to refute what was said in these interviews. And anyway,
do you guys think he'll take the stand? About
Yeah, do you guys think he's going to take the stand? And then the court in Cunningham held consistent that treatises on the rules of evidence that a self-serving declaration is excluded because there is nothing to guarantee its testimonial trustworthiness. If such evidence were admissible, the door would be thrown open to obvious abuse. An accused could create evidence for himself by making statements in his favor for subsequent use at trial to show his innocence. And that was ruled on in Cunningham. And the Supreme Court clarified Cunningham Ian Vanderpool by holding that a criminal defendant's statement could qualify for admission pursuant to another evidentiary rule. The Supreme Court did not, however, reject the fundamental holding in Cunningham that a defendant cannot simply seek to admit his self-serving hearsay without some other hearsay exception. Here, the defendant created many ever-changing statements over the course of the investigation in this case. Like the defendant in Davis, the defendant here cannot seek to build his defense on preserved out-of-court statements unexposed to the rigors of cross-examination. So once again, let's see, Kim Allen says, so the trial is next year now, so much material to go through. He is better to not go on the stand. Traditionally, that's never good. Best to sit tight, Barry. And I think he will be advised to not take the stand. I also think that he will be advised not to take the stand because he can never keep his story straight. And as we know, he had 62 different interviews, and several interviews contradicted each other or, anyway. And they're saying the statements that he makes to his attorney and records talking to his attorney can't be admitted as he, instead of testimony. And number 2, the people are not required to disclose their trial strategy. At the outset, there is not a requirement under Rule 16 that compels the people to provide a pre-trial roadmap of the people's trial strategy. People v. Kilgore, Colorado 2020, that is what the defendant is requesting. The defendant is requesting the court to seek a preview of what recorded statements the people will introduce. The people intend to introduce the defendant's recorded interactions with law enforcement that are relevant to the people's case. The people do not intend to introduce all 50 hours of the defendant's recorded interactions with law enforcement. Similarly, the people intend to introduce some, but not all, of the evidence developed during the investigation. Yeah, Barry will not come across well on the stand. So the people intend to introduce some, but not all, of the evidence developed during the investigation. The people will introduce the evidence that is relevant to the people's case. By requiring the people to disclose in advance of trial what evidence the people deem relevant would be akin to requiring the people to share their trial strategy. No such requirement exists because such a requirement would be unfairly prejudicial to the people. 3, evidence of a declarant's demeanor is not hearsay. In the defendant's request for notice of statements herein, the defendant also contends that his arguments regarding statement admissibility should apply to testimony about the defendant's demeanor around law enforcement personnel. The defendant offers not legal authority for this inclusion. Indeed, the defendant conflates statements subject to hearsay restrictions with non-hearsay evidence. A person's demeanor is generally not hearsay. People v. Lujan in 2018. And reversed on separate grounds, see also People v. Davidson, Colorado Court of Appeals 2022. Victim's demeanor and nonverbal conduct was not hearsay. And in People v. Acosta, Colorado Appeal 2014, holding that a witness's sensory impressions of another's behavior is admissible. So, they're saying that Barry can't say, no, you can't say that I was fidgeting, or you can't say that I was, acting strange or anything like that. That you can't go and what Barry's trying to say is he's trying to dictate what a witness recounts, what they witnessed him doing or what they witnessed him saying, and they're saying that, well, that's not hearsay. If you saw Barry and Barry wouldn't look you in the eye and he's looking down at the ground and maybe he's staring off into space, or or if he was acting super agitated or anything like that, and you observed that, you can say that. That's not hearsay. That's something you witnessed. And 4, the court should not limit argument regarding proposed evidence. The defendant suggests in his motion that if the prosecution seeks to introduce legal argument in support of their notice, this court should rule that the prosecution can do that without inserting into the document the very material that it asks permission to introduce. The people believe the defendant is suggesting that any argument or presentation of evidence in support it's the response to defendant's motion should be curtailed to avoid potential jury exposure to evidence. The defendant provides no legal authority for the proposition that advocates should be limited in their advocacy on a motions issue to avoid influencing the public who may be called to serve on a jury. No such authority exists. Rather, the court has already made clear that the parties shall not make or disseminate an extrajudicial statement that the lawyer knows or reasonably should know will have a likelihood of prejudicing a criminal proceeding. The people have complied with that order. Moreover, Colorado courts consistently hold that proper voir dire of a jury panel is sufficient to overcome any suggestions of prejudice created by extensive media coverage. And then there's some citations, and then they ask that motion be denied, and well, I hope it is denied, but that's one of the things that's going to be a point of contention during this upcoming hearing.
He's certainly trying to keep the media out of this trial.
He's trying to keep everything out of the trial.
But guess what? These papers, they get released.
Yes.
So sorry, Barry.
And then this next one, people's response to the defendant's motion to supplement omnibus order regarding expert disclosures. The people do not see much, if any, difference between the defense request and the court's omnibus order. The people believe the court's order correctly captured the discretionary disclosures enumerated under CR Crim P 16 Part 1D and Part 2B. The people note that many reports have already been disclosed several months in advance of the court's 60-day deadline. Each report thus far identifies an author as requested in this motion. Additionally, the prosecution is actively working with the defense to discover materials far in advance of the deadline. This includes over a dozen defense discovery requests with specific information that is far beyond the scope of what is turned over in other cases, and includes what the defense considers to be impeachment information. The people have gone so far as to request and acquire correspondence between the experts and lab records dating back many years on behalf of the defense, though these things are arguably beyond the scope of the rule of the court order. The people intend to assist the defense team by their own volition moving forward. For these reasons, the people request that the court order continued compliance with the court omnibus order and not take any further action on this motion by the defendant. So basically, this one was saying, okay, we're doing what she's asking us to do, and we are following the rules, and we are asking you to please not put a stupid order out there telling us to do what we already know we have to do and we have been doing. Because that's more evidence of Jane wasting time and, like asking that stuff that...
What do you think they're hoping to achieve by wasting time?
And I think, for one, they were hoping to push back Barry's trial date by making there be so much stuff that needs to be dug through before the trial happens. So basically, what they're doing by all of this is buying Barry more time on the outside. because I have a stinking feeling that once the trial is over, maybe Barry's not going to have any time on the outside. What do you think, Jack?
Oh, we shall wait and see.
Okay, you're still a wait and seer.
Mm-hmm.
Anyway, people's response to the defendant's motion to exclude from pretrial court proceedings persons who may be witnesses at trial or at any motion hearing. Let's see what happens. Oh yeah, please put the thumbs up, guys. The people object to the defendant's motion on the grounds that it does not comport with CRE 615. That rule of evidence excludes witnesses from being present for court proceedings in which other witnesses are testifying. In other words, the rule prevents witnesses from being exposed to the testimony of other witnesses in order to avoid the possibility of witnesses conforming their testimony to other witnesses' testimony. The rule does not and cannot, pursuant to the court's obligation to keep the courtroom open for public observation, prevent witnesses from being present at hearings that do not involve witness testimony. The defendant attempts to stretch the purpose of Rule 615, ensuring that witnesses are not influenced by other witness testimony, to include discussion of substantive legal issues at pretrial hearings. The defendant offers no legal support for this stretch. Indeed, the cases cited by the defendant all involve sequestering of witnesses at hearings, trial and motion hearings, involving witness testimony. People v. Melendez, 2004, sequestration issues arose when sequestered witnesses heard another witness's testimony during trial, not a pretrial hearing. People v. Albo, 2020, was a denial of a defendant's motion to exclude victim from hearing other witness testimony at testimonial hearing and trial, not an abuse of discretion. And People v. Brinson, sequestration, that's easy for me to say, order violation is issue involving trial testimony, not pretrial hearings. People v. Gomez, limited sanction appropriate for prosecution's violation of sequestration order by allowing witnesses to talk to one another during trial, not abuse of discretion. None of the cases involve the pretrial publicity concern that the defendant raises here. Instead, all of the cases that were cited identify the risk that CRE 615 seeks to address: witnesses conforming their testimony to other witnesses. Because the defendant can offer not any legal support for this request, the court should deny their motion. The people have no objection to this court issuing a sequestering order pursuant to CRE 615 for hearings where witness testimony will be provided. The people request, however, that certain exceptions to CRE 615 be recognized here. Specifically, the people request that the court permit the people to designate 2 advisory witnesses: Federal Bureau of Investigation Special Agent Ken Harris and Chaffee County Undersheriff Alex Walker. These investigators have been the lead investigators on this case from the inception of the investigation in 2020. Their involvement and knowledge of this case will be critically important to litigation of evidentiary motions and the presentation of evidence at trial. Moreover, the intimate knowledge S.A. Harris and Undersheriff Walker have regarding this investigation is compartmentalized to a certain degree, as these investigators at times focused on separate aspects of the case. Colorado Rule of Evidence 615 permits from exclusion from the courtroom any person whose presence is shown by a party to be essential to the presentation of the party's cause. In addition to S.A. Harris and Undersheriff Walker, the people note that several members of Suzanne Morphew's immediate family should be permitted to be exempt from exclusion under the Victim Rights Act. Specifically, Suzanne's daughters, Mallory and Macy Morphew, who will be called to testify at trial, should be exempt from exclusion. In addition, Suzanne's siblings, David Mormon, Andrew Mormon, and Melinda Balzer, who may be called to testify at trial, should be exempt from exclusion. CRE 615 exempts from exclusion any person authorized by statute to be present. And that's People v. Coney, 2004. The mandate contained an article to permitted the victim's father in a murder trial to remain in the courtroom. The people note and appreciate that the defense acknowledges this in the motion. So basically, um, this document that had been filed by Barry's team was trying to make sure that Mallory and Macy and Suzanne's siblings couldn't be in the court and couldn't hear the evidence against Barry. And this is showing that there is an exception to the rule of witnesses not being able to see everything, and that's that these particular witnesses are also victims, are Suzanne's direct relatives, and have a right to see everything that happens in there. And obviously, Barry doesn't want the girls or, Suzanne's family to know all the evidence. And then the next one. People's response to the defense motion to require the prosecution to respond to the defense's motions in writing. The people object to the defendant's motion. The people intend to respond to all motion in writing in this case. What did she expect? That they would pick up a phone and call her instead of making a record of their responses to what she had to say? And so, yeah, this is another thing that is probably going to be ruled as moot or something like that. But it's one of the things that has to be brought up there. The defendant has motioned several times to have the court order the prosecution to do things without citing rules or statutes requiring it. The people categorically object to this. The movement in a motion to the court should be required to cite specific legal authority for the request, and he has not done so here. So yeah, he's asking for all responses in writing, but they are doing all responses in writing because they want to have record of what all they say and do. They don't want anything to be off the record. Thank you, Jack. People's response to defendant's motion for evidentiary hearing to exclude summary testimony. The defendant seeks an evidentiary hearing or an evidentiary ruling regarding whether the people should be permitted to call a summary witness at trial. At the outset, the issue raised by the defendant does not require an evidentiary hearing to resolve. A hearing requiring the people's summary witness to testimony about his or her summary of the facts presented at trial would be akin to a pre-trial deposition, something the defendant is not entitled to. Moreover, it is axiomatic that a summary witness who ostensibly would be called to summarize testimony and evidence at the end of the people's case would not be able to perform that task at a pre-trial motions hearing. Courts have permitted summary evidence. Courts that have permitted summary evidence do not permit a pre-trial evidentiary hearing, but rather, in the court's discretion, a voir dire of the witness prior to the witness taking the stand. Murray versus Justin Case Business Lighthouse, 2016. The people therefore object to the defendant's request to set an evidentiary hearing to resolve the issue raised. The defendant's request to summarily exclude summary testimony is not supported by the Colorado law. Instead, Colorado courts have held that summary testimony would benefit a jury because it would help the jury organize and evaluate evidence which is factually complex. And citations, and then the people are permitted to present testimony that summarizes evidence and testimony so long as the witness presents the information accurately, correctly, and in a non-misleading manner. In addition, summary testimony is appropriate where the information is at least admissible, if not admitted. While Colorado courts have not extensively addressed the use of summary testimony in criminal cases, federal courts in the 10th Circuit have permitted the practice in cases like this case, where the evidence, including the number of witnesses presented, is voluminous. And then it's got more citations saying allowing a summary exhibit where witnesses introducing exhibit had personal knowledge of the material included in the summary exhibit pursuant to CRE 1006. And, some more citations. And the court found that the summary testimony would aid the jury in ascertaining the truth. The witness was available for cross-examination, and the court provided a limiting instruction related to summary testimony. And more citations. And then the people anticipate calling over 50 witnesses to testify in this case. The case is currently scheduled for 30 days. Due to the size of the investigation and the volume of information collected, the people believe that summary witness testimony would be materially helpful to a jury in ascertaining the facts. The witness will not testify regarding facts not in evidence, and he does not have personal knowledge of. The defendant will have a full opportunity to cross-examine the witness on the accuracy of his summary. The court is able to provide a limiting instruction regarding the appropriate nature and use of summary testimony. Importantly, the defendant has not clearly defined what he means by summary testimony. In the one Colorado case the defendant relies upon, the court defined summary testimony as testimony about evidence already introduced at trial that provided the jury with an accurate, non-embellishing summary of complicated and voluminous material. The court in Murray approved the use of such testimony. The other authority cited by the defendant, however, creates ambiguity about how the defendant is defining summary evidence. For example, the defendant cites Volkswagen of America Incorporated versus Ramirez, a case that did not mention the word summary at all, but rather discusses expert qualifications. And then they cite some other stuff and say the courts rejected the use of a prosecution's use of overview witnesses or witnesses that testified at the beginning of the trial about what the evidence was going to be presented. And then it goes on with some more citations and says federal courts consistently hold that summary testimony is admissible. And then so they ask the honorable court deny the defendant's motion about summary evidence, which is like after the experts take the stand and all that and do all their psychobabble, the summary evidence would basically be the evidence saying, okay, and long story short, this is what it showed. And people's response to the defendant's motion to exclude profiling evidence. And what's that? Okay. The defendant has asked the court to exclude any profiling evidence at his murder trial. To support the request, the defendant relies on a concession that a prosecutor made in Morphew 1, a previous case from the 11th Judicial District that ended in a dismissal without prejudice. The defendant insists that the law of the case doctrine should bind the people to their prior concession. Okay, let me write this one. What time is this one?
What's your thoughts on the comment section, everybody?
Yeah.
Any thoughts?
Yeah, and anyhow, so let's go over this again. Barry wants to exclude profiling evidence and saying that in Morphew 1, the prosecution team agreed to not use profiling evidence, and then he wants this to be held over to this court, which is a different court. And also, as I mentioned before, the previous court in Morphew 1, the previous prosecution team in Morphew 1 were idiots, or led by an idiot who has now lost her law license, Linda Stanley, former DA, former attorney. Anyway, he wants that to be upheld in this one. So, let's see what, and Kelly, the DA of the 12th Judicial, has to say about that. The defendant has asked the court to exclude any profiling evidence at his murder trial. To support the request, the defendant relies on a concession that a prosecutor made in Morphew 1, a previous case from the 11th Judicial District that ended in a dismissal without prejudice. The defendant insists that the law of the case doctrine should bind the people to their prior concession. As a procedural matter, the defendant's argument fails. The law of the case doctrine has no application to separate cases from separate jurisdictions litigated by different district attorney's offices before different judges. As a substantive matter, his argument fares no better. The defendant has not defined what profiling evidence is, nor has he identified any proposed evidence that would be objectionable. In sum, the defendant fails to provide any legal issue on which the court could effectively rule. The motion should be denied. Relevant facts. In 2021, the defendant was charged with a series of crimes in the 11th Judicial District related to the murder of Suzanne Morphew. When that case was filed, Ms. Morphew's remains had not been located. Those charges were initiated by information and complaint, litigated and ultimately dismissed without prejudice before the case ever went to trial. During the pendency of that former case, the defendant raised a wide variety of issues with the Fremont County District Court: discovery violations, requests for evidentiary rulings, etc. One of those motions sought to exclude profiling evidence at trial. At a motions hearing on February 24th, 2022, without any discussion or litigation about what profiling evidence was or how any such evidence would be preferred by the 11th Judicial District Attorney in that case, the prosecutors indicated that they were not seeking to introduce profiling evidence. With the prosecutor's stipulation, the inquiry ended there. The Fremont Court ruled that any amorphous profiling evidence would be excluded. 2 months later, in April 2022, the 11th Judicial District prosecutors filed a motion to dismiss the case without prejudice, and that motion was granted. Almost a year and a half after the Fremont County case ended, Suzanne Morphew's remains were discovered in Saguache County, Colorado, an area that falls within the 12th Judicial District. The 12th Judicial District Attorney's Office sought an indictment on the single count of murder in the first degree against the defendant. The current case is being prosecuted by attorneys who were not involved in the 11th Judicial District case, and the case is being heard by a separate judicial officer presiding in a separate judicial district. Legal standard and argument. The law of the case doctrine does not apply between two different cases. The defendant's motion suggests that based on the law of the case, this court must adopt and enforce rulings made by a different judge from a different jurisdiction in a different case. That doctrine, however, has no bearing on this situation. The law of the case generally provides that prior relevant rulings made in the same cases are to be followed. And then there's some citations. The concept is mandatory when evaluating a previous pronouncement of an appellate court in a case that has been remanded back to the trial court. There, the trial court must follow the appellate court's directive. It is discretionary when a trial court is thinking about reconsidering one of its own rulings. There, the doctrine is flexible and allows a trial court to rethink the previous orders. The defendant's motion, however, fails to recognize a fundamental principle of this doctrine. These concepts guide a court when it has been asked to reconsider a ruling in the same case, whereas the defendant here is asking this court to import a ruling from a different case. But as the Sixth Circuit put it, the defining feature of the law of the case doctrine is that it applies only within the same case. And then there's citations for it. And let's see, go beyond the citations. The current case may charge the same defendant with a crime related to the same murder, but is clearly not the same case. It was filed by different prosecutors in a different court after previous charges were dismissed without prejudice and new evidence was uncovered, namely the discovery of Ms. Morphew's body, which had been disposed of in a different judicial district and which had a chemical in the bones that only the defendant had access to in the area. See, People v. Small, Colorado, 1981, recognizing that a dismissal of criminal charges without prejudice leaves the matter in the same condition as before the charges were filed. The defendant has not, because he cannot, point to any legal authority to support his claim that pre-trial evidentiary rulings made in a different jurisdiction, in a different case, had any control over the court's decisions here. 2. The defendant's motion should be denied because it has not presented anything concrete for the court to rule on. On the merits, the defendant's motion fails. It does not provide any definition of what the defendant labels as profiling evidence. It does not provide any examples of profiling evidence that the people intend to introduce, and it does not attempt to distinguish potential purposes or admissibility theories for this unidentified profiling evidence. Without a clear definition, an actual piece of evidence, or an argument distinguished by the purpose of admission, this court cannot meaningfully decide this option. The profile label is not helpful in distinguishing admissible from inadmissible expert testimony. Rather, it has a citation. The Colorado Supreme Court recognized the distinction that the defendant fails to acknowledge here. It offered to rebut a defense, or if the evidence was objected and widely accepted in the field. The prosecution introduced expert evidence regarding the profile of a drug courier. The expert witness testified that he looks for certain characteristics of a drug courier that he is familiar with. He did not rely on any research or material developed in his field, only his expert experience. Moreover, the expert witness opined that the defendant in that case fit the characteristics, and the prosecutor argued the same during closing argument. The Salcedo court distinguished the inadmissible evidence in that case from admissible expert testimony that was offered to rebut a defense or was supported by objective research. In this case, the people anticipate that the defense will argue that law enforcement was myopic in their focus on the defendant. For example, expert testimony supported by substantial experience and research in criminology will be helpful to the jury to put law enforcement's decisions in context and rebut that allegation. Ultimately, without a definition of what the defendant means by the term profiling evidence, and without offers of proof of any proposed evidence, the court is not in a position to decide this motion in a vacuum. Therefore, the people request that the court deny the motion and address evidentiary issues as they are raised at trial. So basically, Barry didn't want any profiling evidence, and that whole document was showing. Yeah, please give me a thumbs up. That whole document was showing that profiling evidence, depending on what Barry means by profiling evidence should and is admissible in court when somebody who is a trained profiler gives evidence about their, profiles. For instance, if they said that someone who would do a crime like this would, have this kind of profile or something. So, let me see now. Where are we on this? Oh, we have reached 37 now, which also, okay, here we go.
So how many pages have you gone through today?
Yeah, a lot, especially.
How many more do you have?
A lot. So, do the Wales ones. Later, this one is the response. So we put this over here for a moment, and we get into This one's kind of an important one, so I'm going to put it on the thing too. I mean, they're all important, but
So when do you think the
Here we
trial
go.
will start?
we have no idea yet when the trial is going to start. Somewhere between January and July, because the prosecution said they would like it to start in January of 2027, and the defense said that they didn't think they'd be ready until at least May, if not later on in the year. And so then the judge finally said July
The
is
judge has
the
made a
deadline.
ruling like this already once. He said, "I want to."
Or are you talking about David's trial?
No, not David.
Okay,
Mary's
this one?
trial.
Okay. Anyway, next we've got the people's response to defendant's motion to exclude victimology testimony. And summary of the argument. The defendant has asked the court to exclude any victimology evidence at his murder trial. To support the request, the defendant relies on a concession that a prosecutor made in Morphew 1. And once again, we know that we're arguing here that you can't use the rulings from Morphew 1 to be used in Morphew 2 because they're two different cases. Anyway, in Morphew 1, a previous case from the 11th Judicial District that ended in a dismissal without prejudice, the defendant insists that the law of the case doctrine should bind the people to their prior concession. As a procedural matter, the defendant's argument fails. The law of the case doctrine has no application to separate cases from separate jurisdictions litigated by a different district attorney's office before different judges. As a substantive matter, his argument fares no better. The defendant has not defined what victimology evidence is, nor has he identified any proposed evidence that would be objectionable. In sum, the defendant fails to provide any legal issue in which the court could effectively rule. The motion should be denied. And then we get into some juicy bits, the relevant facts. In 2021, the defendant was charged with a series of crimes in the 11th Judicial District related to the murder of Suzanne Morphew. When that case was filed, Ms. Morphew's remains had not been located. Those charges were initiated by information and complaint, litigated and ultimately dismissed without prejudice before the case ever went to trial. During the pendency of the former case, the defendant raised a wide variety of issues with the Fremont County District Court. I think this apparently is identical to the argument of the other until we get down to, at a motions hearing on February 24th, 2022, without any discussion or litigation about what victimology evidence was or how any such evidence could be proffered by the 11th Judicial District Attorney's Office. In this case, the prosecutors indicated that they were not seeking to introduce victimology evidence. With the prosecutor's stipulation, the inquiry ended here. The Fremont court ruled that any amorphous victimology evidence would be excluded. 2 months later, in April 2022, the 11th Judicial District prosecutors filed a motion to dismiss the case without prejudice. That motion was granted. And then we go to how the law of the case does not, just like I just read in the other one, that these are two different cases. Morphew 1 and Morphew 2 are not the same case. And that, let's see. Some of this is just the same as the other one because they're using the same reasons why. This shouldn't. But then we get into some different stuff, which is that the court should not blanketly exclude an undefined category of evidence. There is no legal definition of victimology evidence, nor does the defendant offer one. The term has been used in several different factual settings in Colorado courts to describe different types of testimony. For example, the Supreme Court in People v. Hampton held that a victim advocate could testify about rape trauma syndrome as an expert in victimology. Um, the court in People v. Garza used the term victimology to describe a blind clinical psychologist expert endorsed to testify about child sex assault trauma, outcries, dynamics, and effects. And the Court of Appeals addressed a trial court decision to allow an expert in domestic violence cases to assist the jury in understanding cycle of violence and victimology. In other states, the term victimology has been used to describe expert testimony into certain victim characteristics that led to victimization. In Simmons v. State, holding that the field of victimology is a reliable field of specialized knowledge, rendering the expert's testimony relevant and admissible. State v. Spalding, permitting testimony regarding the victimology of the murder victim or testimony regarding what aspects of the victim's life would make him the target of that crime. People v. Mauser. Let's see. Like Colorado, states have labeled testimony regarding victim trauma and behavior as victimology. And federal courts have accepted victimology testimony in human trafficking cases to describe common research-supported characteristics of trafficking victims. Federal courts have upheld the trial court's admission of victimology testimony, defining it as testimony addressing the murder victim's relative risk factors for victimization and what the crime scene suggested about the motivation for murder. And in U.S. v. Alanke, the Court of Appeals upheld that expert victimology testimony was admissible to explain the behavior of an involuntary servitude victim. Oh, and Jackson reminded me to ask you guys to like and subscribe and hype this live. Let's see. In the cases cited above, the trial court's decisions to admit victimology evidence, however that is defined, were upheld on appeal. There is no legal support for the defendant's request that the court blanketly suppress all victimology evidence without knowing what that evidence would be and how it would be used. Specifically, victimology evidence was found to be helpful to a jury to understand victim trauma. In other words, victimology evidence was found to be helpful to a jury to understand a crime scene and advance investigative avenues. Asking that all victimology evidence be excluded without any discussion about theories or admissibility of or proof is untenable. Here, the defendant makes no attempt to explain what he means by victimology testimony in this case. It is anticipated that the defendant will argue that the police were myopic in their focus on the defendant. If the defendant advances this argument, testimony regarding decision-making backed by research and experience would rebut this argument. And then, in any event, the defendant, those were citations that I was skipping over and getting to the end here. In any event, the defendant has not identified what he seeks to exclude, nor have the people yet submitted their expert disclosures that may fall under any amorphous definition of victimology. Therefore, the court is not in a position to decide this motion. And then there was a response from Barry's team. Mr. Barry Morphew replies to the prosecution's response to motion D037, motion to exclude so-called victimology testimony. His request that this court exclude testimony or evidence, whether introduced through lay or expert witnesses, of so-called victimology or pattern of life testimony, and exclude the hearsay that would be elicited by introduction of this type of evidence. The prosecution appears to concede that if it wants to introduce opinions based on victimology or behavioral analysis, it must give proper notice under CRE 702, People v. Shrek. Because this subject matter may not be admitted through a lay witness, thus at the minimum, the court should so order. However, And yes, Penny, I think that Barry wants to be a bully. He's running out of people to bully, and so he's trying to bully the courts. Um, However, this court should go further for the reasons stated in Motion D037 and its detachments, including the authority and arguments in Morphew 1. They're citing Morphew 1. And Morphew 1 has no bearing on Morphew 2. Anyway,
Citing Morphew 1.
this is the defense now.
Yeah.
Yeah, this court should bar the prosecution from introducing this evidence at trial. Victimology, behavioral analysis evidence is presumptively inadmissible and should be ruled inadmissible here. Oh, no, hell no, it's not. It is very admissible. It is very important, and it is something I very much understand because of my background in psychology. It is real, and Barry can suck it. No. Anyway, getting back to the document. This court should reject the prosecution's assertion that it doesn't know what Mr. Morphew seeks to exclude. Mr. Morphew referenced the prior litigation in Morphew 1, where the government introduced such evidence at the preliminary hearing through the same government witnesses who testified in the grand jury in Morphew 2 about the same thing, sometimes using a slightly different label. See the grand jury transcript quoted in Motion D037. In Morphew 1, the government announced its intention to introduce an expert in behavioral analysis. Guess what? That's a real science, people. Anyway, apparently Barry's team doesn't know that. In opposition, the defense referenced and attached numerous articles. There is no mystery. As the government's own grand jury witness testified, behavioral analysts are profilers. So the behavioral analysis unit sits at headquarters and has teams of profilers that look at different types of cases. Okay, well, in a way, that's true, but that's also very admissible stuff, and these are trained people that are... I'm getting away from this, but... okay. At the preliminary hearing in Morphew 1, the people introduced what it called victimology. See attachment, Morphew, blah, blah. As the Morphew 1 motion points out, the attorney representing the people used the term almost a dozen times. In its later filed expert witness notices in Morphew 1 and the grand jury in Morphew 2, the terminology shifted to behavioral analysis. The prosecution knows what it is and simply employs a shell game with the labels. Yes, profiling is behavioral analysis. Behavioral analysis being the technical term for it, and profiling being the one that everybody understands because of... Yeah. Anyway, the prosecution cites two unpublished Court of Appeals cases. Both predate Morphew 1, and neither applies to this case. Writing for the three-judge blah, 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 Judge Yoon referred to the child sex trauma testimony as victimology, but that is not how the evidence came in at trial. At trial, a licensed clinical psychologist called in... Amy was called in as an expert in clinical psychology, including child sexual assault trauma, outcries, dynamics, and effects. This case concerns the unique field of child sex assault trauma and bears no relationship to the way the people have been using victimology or behavioral analysis in this case. The prosecution cites People v. Hampton, but fails to acknowledge that Hampton was partially abrogated by Schreck. Decided almost a quarter of a century ago by a divided court, Hampton held that expert testimony concerning rape trauma syndrome was admissible to explain delay in reporting a sex assault. In that case, unlike here, none of the expert's testimony concerned the particular alleged victim. Important to the court was the fact that the expert testimony was not used to establish that a crime had been committed. Again, this case doesn't make the government's evidence admissible here. And then they cite People v. Velasquez, and they say the out-of-jurisdiction cases are inapplicable. Most were decided under standards not used in Colorado. They're talking about the Supreme Court of Appeals cases, and they're saying these are not applicable in this case because they're not Colorado cases. Guess what? The federal court's decisions are applicable in all 50 states, and are cited often. So anyway, and then I'm wondering why they include. I'm just going to start this whole paragraph here, and you guys can make your own connections here. I mean, this is Barry's team, and this is what they're having to say. The outer jurisdiction cases are inapplicable. Most were decided under standards not used in Colorado. In Simmons versus State, which is a Court of Appeals thing, expert testified on a sentencing issue in a capital case, specifically whether the offender received sexual gratification during the murder.
Very.
And the testimony referenced in State v. Spalding certainly could not be admissible in Colorado because the testimony wasn't challenged on appeal. The Spalding court, deciding a post-conviction petition filed in a death penalty case, declined to issue any rulings on the issue. So anyway, I wonder why they specifically are saying that
we're gonna find out a whole lot
Yeah.
of date when this file
That's kinda-
finally starts.
that's kind of a creepo little thing, right? And then some of the cases the prosecution cited say nothing about the subject. In State v. Grestifico, unpublished, a clinical psychologist treating child sex assault victim testified.
Easy there.
Well, yeah, that's their document. But anyway, they talk about that one, and then they say that expert testified that the victim's behavior was generally consistent with that of a victim of sexual or physical
The
abuse.
video's gonna be so flagged.
And, oh boy, yeah. Anyway. It's talking about S trafficking. Please like, subscribe, and hype this live. And so anyway, their response to what the prosecution was saying is to then throw in a whole bunch of fluff about saying, comparing the testimony to a lot of different SA cases. And let's see. And then it talks about inadmissible overkill testimony and stuff like that. And then we get to another interesting thing that they're citing. United States v. Al-Zaki was a highly unusual case involving a Kuwaiti couple that forced a Sri Lankan domestic worker into involuntary servitude. The testimony concerned the exceedingly uncommon phenomenon of domestic servant abuse in the present-day United States. The testimony was targeted towards the actus reus to counter the defense argument that the door was often unlocked, implying the alleged trapped victim could have left or escaped, so she must not have been held against her will and subjected to involuntary servitude. There was no objection at trial. Applying plain error review, the court refused to reverse the conviction based on the trial court's ruling that allowed the government to admit evidence about repressive Kuwaiti customs and practices toward domestic workers. Apparently, Kuwaiti police were under orders to shoot undocumented domestic workers who ventured out alone. This case has nothing to do with Mr. Morphew's case.
That's very strange.
It doesn't matter whether the government labels it profiling, pattern of life, victimology, behavioral analysis, or some other name. The shifting label is merely a shell game and attempt to avoid the undeniable rule that this evidence is not admissible. It violates all the constitutional provisions and rules of evidence identified in this motion and the Morphew 1 motion. It is unreliable, unhelpful, and unfairly prejudicial. So basically, what Barry's team is saying, psychology isn't real. That there is no way of analyzing a person and saying
Science. They're denying science.
They're denying science. Okay. So anyway, this court, and of course, the backbone of this whole thing is saying, well, Morphew won, Morphew won, Morphew won. This is not Morphew won.
They're quoting
Yeah,
their own client's first trial
yeah.
as a case law. Is that what they're trying to?
And then, yeah, and now here they go, and they say it again. This court does not write on a clean slate because Morphew 2 is a continuation of Morphew 1. And the hell no, it's not. And,
Well, there was no body.
yeah,
In
it
Morphew
was a
1.
totally different case, and it took place in a different, Anyway, so they're saying this is a continuation of Morphew 1. And the prosecution is saying this is not a continuation of Morphew 1. Morphew 2 is its own case. Anyway, the prosecution urges this court to regard the instant case, Morphew 2, as if it were not a continuation of Morphew 1 prosecution. Its approach would cause a violation of Article 2, Sections 3, 16, and 25 of Colorado Constitution Amendments 6 and 14 of the United States Constitution. Of course, the district court may reconsider its rulings if there are changed circumstances or changes in the law. That is not the question. The question is a matter of the burdens that... Oh, they're purposely misunderstanding what Ann Kelly said. Saying that the court should reconsider its that a court can reconsider its earlier... This court is not the one that decided on those other things. This court has not had this before them before. This is not a continuation of Morphew 1. I can barely read this dribble from the other side there. So if the government is correct, this court writes on a clean slate, and the burden is back with Mr. Morphew, even though both parties, Mr. Morphew and the court of the state of Colorado, already litigated this issue, and the government's current position did not prevail. If the burden is on the government because fairness dictates this court follow law of the case principles, then the government must identify the evidence it seeks to admit and convince this court that the prior rulings are error or no longer sound due to changed conditions, is what he's saying now.
What it says is the burden is on the people to convict. This is their burden, yes?
Yeah, but that's not what this is talking about, though. He's saying, or this paper is saying that well, he has a bunch of gobbledygook, but basically he's saying it's saying that they say okay. It's saying that this prosecution, this district attorney, needs to prove that the original rulings to not admit this kind of testimony was wrong or something, even though this isn't part of this hearing. This isn't part of this trial. And they say, oh, let's go back and rule on what happened in the other one.
No, they're going to just move forward.
Yes, they're just moving forward because this is a different case. On the question of whether victimology profiling behavioral evidence is admissible in the state of Colorado, nothing has changed between Morphew 1 and Morphew 2. It was inadmissible then, and it is inadmissible now. The only reason why it was inadmissible then is because the prosecutor's office, the DA, was an idiot, and she just blatantly said, no, I'm not going to use that. So it wasn't ruled inadmissible. The prosecution said, we're not going to use that.
Do you think they could have prosecuted him in Barry 1?
I suppose they could have if they wanted to use that, and they could have said, yeah, we're going to use that. But they said, well, we're not going to use that because, she got her head up her butt. Anyway, that's why she's not a lawyer anymore. So... in this case, a party, the people of the state of Colorado, engineered a change of venue by dismissing the case and refiling it in a different jurisdiction. That move doesn't make it a separate case. The parties are the same. Barry Morphew and the... Excuse me. Did you hear what that said?
Read it again.
In this case, a party, the people of the state of Colorado, engineered a change of venue by dismissing the case and refiling it in a different jurisdiction. That move doesn't make it a separate case. The parties are the same. Barry Morphew and the people.
That would mean that.
That would mean the people somehow moved Suzanne and buried Suzanne in the other county in order to change jurisdictions.
She was located.
Yeah, but that's not. It's saying the people engineered a change of venue.
Created.
Yeah, that they created a change of venue by That's
That's some backwoods freaking court system there.
if it were even possible, but no. What are they saying? That the people of the state of Colorado engineered this. Almost
That's
none of the
ridiculous.
cases, yeah. Almost none of the cases the people cite are about the context here, where a district court presiding over the same parties in a case alleging the exact same offense and the same victim is asked to honor the prior district court's rulings on identical legal issues. Okay, first off, this is not the exact same case, and it does not have the exact same parties, and it is not the exact same offense. It is the same victim. It is Suzanne Morphew is the victim, but excuse me, it's a different district court, and Barry is the person on trial, but it isn't even the first. It's not even the same charges. Before it was like a domestic violence type thing where maybe he snapped or whatever was the type of murder charge he was facing before. Now he's facing murder one, premeditated murder. So
Premeditated gonna make it real serious.
yeah,
This is capital punishment stuff.
and then they
If
make
there
some
were
more
such
citations to try to fluff and fill out their stuff. Let me see if I get to anything. Let's see, more. Oh, like and subscribe and hype if you can.
Mama.
Wow, yeah, I need another drink. Oh boy. Oh my gosh. They're citing a whole bunch of other cases, pages and pages of it, that, and of course, they keep saying Morphew 1. And they end with, at first blush, the prosecution's string cites may look impressive, but an actual reading of the cases belies that superficial impression. None of them addresses the fundamental due process rights that animate the present litigation. None of them concern the umbrella of protections provided by the Constitution of the State of Colorado and the U.S. Constitution. Blah, blah, blah. Theirs was much more fluff, and I can tell you right now that the ones that were cited were quite relevant in the prosecution's stuff. Now let me look at. Don't take those. Those are coming up next. So that was 37, and now we go to E39. Okay. People's response, nice and short. People's response to defendant's motion to exclude witness testimony about looking guilty, D39. Ann Kelly, District Attorney in and for the 12th Judicial District, State of Colorado, respectfully files this response to the defendant's motion to exclude witness testimony about whether the defendant looks guilty. The people do not intend to elicit testimony about whether witnesses believe the defendant looks guilty or about whether they believe the defendant looks credible. And then response from Barry's team. They're replying to the response about excluding witness comments or beliefs that Mr. Morphew looked or looks guilty. Mr. Morphew provides the following reply to the prosecution's response to his motion to preclude inadmissible testimony about the witnesses or some other person's comments on veracity or credibility, such as Mr. Morphew looked or looks guilty, suspicious, or untruthful, or similar comments. Because the prosecution does not object, this court should enter the order and prohibit the evidence described in Morphew's motion. This court should enter an order prohibiting the prosecution from presenting any testimony, opinions, or statements from any witnesses similar to statements that amount to comments on veracity or credibility, including as examples he or she believed or believes that Mr. Morphew looked guilty, looks guilty, looked untruthful, or looked suspicious, or looked like he's hiding something. Pretty cray-cray, huh? And some of that goes back to, that is going to be decided, and it does seem to me that that's probably going to be not granted or granted in part or something like that, because for one thing, the prosecution isn't looking for that kind of testimony, isn't trying to elicit that kind of testimony, but also we've already seen in previous documents where they cited that whether he appeared, what he looked like, how he was acting, how that made the witness feel, that is admissible because that's observations, it's not hearsay, etc. Okay, that one's 40. That's an important one. Let's see, what's the next one? I'm getting all discombobulated with these papers all over the place. Like, subscribe, and hype this live while I'm trying to figure out where my next paper went. Okay. And then 38 was the response of... Okay. Next we've got the prosecution's reply to the motion to exclude opinion testimony on the significance of evidence, the prosecution's theory of the case, and Mr. Morphew's mental state or credibility. Mr. Morphew provides the following reply. Oh no, that's their reply. So that is for number 38. Let me see. Where is... That's his reply. And that's 43. Jack, I think I dropped some papers.
Mm-hmm. GG now.
So those two go together. Did I not drop any?
We have all these up here. See here.
Okay.
Are they these?
Sorry about getting a little bit scrambled here, folks. Let me see what I've got over
We only
here.
have over 100 pages.
Okay. Then other things that we had. Okay, I'll discuss that one later. As we have what was filed by Jane was a reply to the motions related to jury selection procedures and defense 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, and 33. The prosecution has responded to 11 motions in one document, and Mr. Morphew has a similar response regarding each. Therefore, Mr. Morphew states, for most motions, the prosecution agrees with Mr. Morphew or does not object to the relief requested, which basically isn't any relief. He's just, these were a whole bunch of documents that we're stipulating what is already protocol for jury selection. Number 2, in general, these motions are best resolved through a conference with the court, the jury commissioner, and both parties. The prosecution does not oppose such a conference. In counsel's experience, many of these issues and those 11 motions can be resolved quickly at such a conference. Mr. Morphew is moving for continuance of trial and motions hearing. As explained in that motion, his attorneys are not able to be ready for a trial as currently scheduled. One result of the present circumstances is that his attorneys have not had time to review the prosecution's responses thoroughly to determine for which of the above motions a reply would assist the court and or further preserve arguments. Thus, Mr. Morphew requests that this court continue the jury procedures motions for a time closer to the newly rescheduled trial. And that one, I already did that one. And then we'll get to okay, and this one is a reply to the motion to exclude opinion testimony on the significance of evidence, the prosecutor's theory of the case, and Mr. Morphew's mental state or credibility. Mr. Morphew provides the following reply to the prosecution's response to his motion to preclude inadmissible opinion testimony about the significance of evidence, the prosecution's theory of the case, and Mr. Morphew's mental state or credibility. The prosecution's only response is that they believe this court cannot rule without more information about any specific testimony or evidence the defendant seeks to exclude. However, Mr. Morphew has been specific enough for this court to rule. Because the principles of law are clear and indisputable, the prosecution does not dispute them. This court should grant the motion. Mr. Morphew's motion, let's see, when they say discovery, do they mean new discoveries by the new DA? Yes, they do. They mostly mean, but they also mean information, whatever information from the interviews with Barry and evidence that was gathered during the first trial, but they're not using what was used in the first preliminary hearing. That testimony and stuff. They're not using that. They're using the evidence that was uncovered. They're using, and all of that is discovery, and all of Barry's recorded interviews with the police and stuff. That's all
the body cam footage as well.
All the body cam footage, all of that is in discovery. Anyway, Mr. Morphew's motion gives numerous examples of testimony that would violate the rules he sets forth. And then he's got this whole list, like law enforcement testimony commenting on why this or that fact should be regarded as important or significant. When a video or a photo is shown, speculation about who the person in the video or the photo what the person in the video or photo must have done, even though that is not depicted or seen in the video or the photo. Anyway, then it says these are all the examples of what Barry's arguing about, and by not responding, the prosecution concedes that the above testimony is inadmissible, and I seriously doubt that the prosecution is saying that it's inadmissible, and I believe that's one of the things that's going to be talked about during next week's hearings, is that they're going to discuss these things that Barry's arguing about, and the wording people have. Jack's stealing my pen, and that is 40 that I need to. Where are my notes? Where I was writing down the time?
Oh, they were here.
Okay. And now we'll go through. It's just a few more. Anyway, now we're going to go Yeah, and stick around for question and answer. Right now, we're going to, let's see, the people's response to the defendant's motion in Lamine to exclude screening testimony. The defendant seeks a ruling from the court pre-trial to exclude what the defendant labels as screening testimony. This request is overbroad and vague. The people understand the comments or evidence regarding law enforcement's opinion about probable cause to arrest, the process to determine probable cause, or the grand jury's decision to indict are irrelevant. That restriction is supported by Colorado case law, and then a whole bunch of citations. The defendant's own definition of screening evidence, as the term has been used in recent appellate decisions, is overbroad. The defendant's definition or testimony designed to bolster the decision-making process or judgment of law enforcement or other actors, emphasis added, does not comport with what Colorado courts understand screening evidence to be. This definition, including the phrase judgment of law enforcement, would eliminate law enforcement officers from testifying about what they did in their investigation, and more importantly, why. In addition, the definition would eliminate law enforcement witnesses' ability to respond to the defendant's likely allegations that law enforcement focus exclusively on the defendant. The defendant also seeks to prevent the people from calling witnesses who relied on such information. Such a restriction would eliminate the majority of law enforcement officers from testifying simply because they relied on their own judgment and determined based on their investigation that the defendant murdered Suzanne Morphew. While they are clearly not permitted to talk about their opinions of the defendant's guilt on the stand, they all would nevertheless fit into defendant's overbroad definition. Importantly, the cases that have been addressed screening testimony do not categorize the evidence as bolstering law enforcement, but rather categorize the evidence as bolstering the case itself. While perhaps a minor distinction, it is clear that the defendant seeks to eliminate the people's ability to ask law enforcement witnesses about the reasons that they took the steps that they did in the investigation, or the evidence that supports the charges against the defendant. The people know and understand the rules of evidence and case law related to the relevancy of discussions about probable cause and process at trial. To the extent the defendant is objecting to the type of evidence at issue, the people do not intend to introduce that type of evidence. The extent the defendant's definition of screening evidence is broader than cases cited by the defendant, the people object. So, basically, Barry was wanting to eliminate all testimony of police, law enforcement, and was doing it under a blanket thing. And so the DA was saying, we're not going to say what is your opinion, but we will say, what was your process? And asking what their process was is not supposed to be disallowed. Anyway, people's response to the defense motion to prohibit any reference to the defendant's post-arrest silence in invocation of his constitutional rights. The people do not intend to elicit testimony regarding the defendant's exercise of his rights to remain silent, nor do the people intend to comment on the defendant's choice to exercise his rights. So they're not going to say, oh, Barry talked a lot and then he decided to claim the fifth. They're going to say, okay, he claimed the fifth. Please like and subscribe and hype, etc. And now we get into more, and I don't know what Jack is trying to say. Maybe you could say in words.
The right to remain silent.
Oh, yeah.
I thought we should talk about that.
Oh, okay. Well, the right to remain silent is an important one, and I don't know of any trials where the prosecution then said, and then at that point the defendant exercised his right to remain silent.
And then he decided to say, lawyer.
Yeah, they don't do that. They just talk about what was said in interviews, and if there wasn't anything said in interviews, they just don't bring it up. Okay, people's response to the defendant's motion in limine regarding narration of videos. The defendant seeks pretrial rulings on matters that are more suitably resolved with contemporaneous objections. There is no bright line rule regarding a witness's ability to comment on videos or photographs. The court Vergari addressed a specific set of facts and circumstances that may or may not present themselves in trial in this case. Questions regarding orientation, focus, relevance to the investigation, and others asked during the airing of a video may be relevant and necessary depending upon a particular picture or a particular video. The court cannot rule on a defendant's blanked objections without actual evidentiary context. For that reason, the people request that the court deny the defendant's motion. So that one, he wanted people to not. He wanted people to not be able to testify while they're on the stand. There's a a photo or a video up there. They're not allowed to say, okay, well here's the photo and it's it's oriented this direction. There's the top of the picture, and the top of the picture is the north or whatever. That kind of thing. They're not allowed to. The defense wants them not to be allowed to narrate what is there, and they're saying, well, please deny that. So yeah, that's something that you would want to see in court, where they would say, okay, here's this picture, and then if Barry didn't like the picture, he gets that he could have his defense say objection, prejudicial, or whatever.
Prosecution wants to explain the photograph.
Yeah, and wants to be able to say,
This is.
yeah,
This happened here. This
Yeah.
happened when.
yeah, and
This
and
photo
Barry,
was taken at this time.
yeah, and the defense is not wanting them to be
And
able
Barry
to
wants
say
them to just
the
shut up
context
and
of the
just be
pictures.
quiet.
Yeah.
Okay.
People's response to the defendant's motion to exclude law enforcement from wearing uniforms or insignia in the courtroom. The defendant asked the court to equate rules prohibiting hats and lewd T-shirts in the courtroom to law enforcement officers wearing their uniforms.
The first thing you do when you go into the court, what does the judge say? Hats off now.
Yeah, well, the defendant is saying that not only, because he knows that the hat's off and all that, what he's saying is that the same thing as law enforcement's wearing their uniforms, so he wants them to not have their uniforms.
But
He cites zero legal support for this ask. The defendant opines only that the mere presence of police in a courtroom is prejudicial. But they're going to have to identify themselves as being police officers when they're on the stand anyway, so I don't understand what the problem is if they happen to be wearing their uniforms when they go in. What do you think, Jack?
they are police officers. Maybe they're in the middle of something.
Yeah, because they have to appear in court. Maybe they're going to be working too. Who knows? And then like work in the morning and come in the afternoon, or they're gonna freaking be in court, and then when they're done with their testimony, they're gonna go work. So who knows? Anyway,
Yeah, I don't know what to think about that.
it is unclear what disruptive and unfair message the defendant believes police officers send in their uniforms, but no court in the state of Colorado that the undersigned is aware of has ever held that the presence of a police officer in a criminal courtroom during the trial of a criminal case is inherently prejudicial to the defendant.
Well, it validates who they are.
Neither do the cases cited by the defendant come close to standing for this absurd proposition. The cases cited by the defendant to support the request to limit all indications of the presence of law enforcement in the courtroom actually relate to rules in civil cases about people bringing guns to civil pretrial depositions that are not typically held in courtrooms, but in conference rooms and law offices. Other cases cited by the defendant include questions about whether restricting the defendant from wearing political T-shirts that actually say political words is a violation of a defendant's First Amendment rights. Importantly, the Supreme Court in Aleem focused exclusively on whether the court was reasonable in limiting the defendant's political speech. Police uniforms worn by police officers are not speech. Unless the defendant can articulate why police officers wearing police uniforms would constitute conduct disruptive to the courtroom environment, the court should rely on this motion. The motion that said
Like we were
cops
expecting
can
to
wear
see
uniforms.
police officers in the courtroom.
Yeah, Barry doesn't want any uniforms in the courtroom.
This is where they live. They go to court.
Okay.
All right.
And then we have the people's response to the motion to exclude from trial. Okay, to exclude from trial any image of the defendant that reflects him in custody or commenting or asking witnesses questions about his incarceration. The people do not intend to introduce mug shots or booking photos of the defendant. To the extent the defendant's motion seeks to exclude that specific evidence, the people do not object. The defendant, however, asks to expand and stretch Colorado case law to untenable lengths. The defendant seeks to exclude testimony about the defendant's incarceration without explaining to the court what the defendant's specific evidence the defendant seeks to exclude. The defendant has not cited a single case that supports the nonsensical argument that no evidence of a defendant's arrest or time in custody could ever be relevant. That is not the law. To the extent the defendant here seeks to exclude relevant evidence beyond that mugshot case law prescribes, the people object. So, yeah, that one, the people are saying, yeah, we're not going to use his mugshot. We're not going to show his mugshot in court. And then they're going, but, you know, what do you mean we can't say you were arrested? We can't say that you were in jail. We can't say, we can't say anything about your arrest or how you acted. That doesn't make any sense. You bounce the camera all over the place, man.
I do that.
Police uniform is visually influential to a jury. Except for the police are identified as being police before they testify. So, I don't know.
Don't hit the camera.
And then, police in their uniform might throw the case as opposed to say, bam, in her bones. Yeah.
Maybe he feels bullied by the police.
He doesn't want anybody to know that the people testifying are cops, so he doesn't want them to be wearing uniforms, I guess. And I recall that most of the people that testified, some of the cops had uniforms during the Morphew 1 that we're not supposed to cite, and some of them didn't. Just depending on whether they were going to be working that day, like you said. They don't just go, oh, I'm going to go to court today, so I'm going to put on a uniform.
Some of them get the day off, but I wouldn't count on it.
Yeah. They need money. They need to be paid. Anyway, then before I get into the big one that's going to be litigated during next week's pretrial motions hearings, is this paper here was filed by Jane, and it was filed on May 21st, 2026. And Jane says that she's requesting a full transcript of the March 30th hearing. And so then I went and did my due diligence to discover that hearing that she wants the full transcript for was all of 8 minutes long. It was an 8-minute long hearing. And in that, her legal partner, the other attorney whose name is David Beller. In that one, David Beller said that they were going to be wanting to get information about what experts we're going to be and be able to argue about whether or not the experts could be used. Please like and subscribe and hype if you can. Now we're getting into the last motion and reply. Well, last response to a motion and reply. And this one is the one that means the most to me and probably to all of you too, because it's the one that I feel like it is trying to silence Suzanne. And anyway, here we go. This is the responses to defendant's motion 40, which we discussed in a previous video. It's a heavy one. It's one where they want to exclude out-of-court statements attributable to Suzanne Morphew. And this one is the response from Ann Kelly, the district attorney. And this is the one that I was really waiting on, when I read the defense's motion to not allow
Water break.
to not allow Suzanne's voice to be heard. So here we go. A response to that. The defendant seeks a pretrial order excluding all statements attributable to Suzanne Morphew without identifying the particular statement at issue or raising objections based upon the specific context of those statements. The court cannot rule on this motion. The people have filed a notice of intent to introduce statements made by Suzanne Morphew admissible pursuant to Colorado Rule of Evidence 807. The statements preferred are not testimonial statements. The Confrontation Clause prohibits the admission of hearsay statements regardless of the exceptions that are testimonial in nature. A statement is testimonial when made under circumstances that would lead an objective witness reasonably to believe that the statement would be available for use at a later trial. Statements do not fit this definition are governed only by hearsay rules and exceptions. The vast majority of Suzanne Morphew's statements that people will prefer for admission are not made to law enforcement, nor are they made in the anticipation of her future murder trial. And then they do a citation where it says that statements are testimonial if the primary purpose is to create an out-of-court substitute for trial testimony. The only statement that comes close but does not meet the definition of testimonial. Oh dear, here's my time. I need my pen. Okay? This is important. Okay, I'll use a highlighter. Anyway, so remember they were wanting to exclude Suzanne's statements, and this is an example. The only statement that comes close but does not meet the definition of testimonial is a 911 call Suzanne Morphew made before she was murdered unrelated to that murder. The statement will be noticed in the People's 807 and 404B notice. Those statements are akin to statements identified as non-testimonial by the Supreme Court in People v. Davis. In November of 2018, Suzanne Morphew was home with her best friend, Sheila Oliver. The individuals at home, including Suzanne, noticed alarming activity outside her home late into the evening. Suzanne's home was secluded by forest, and access to her property was restricted. Suzanne saw headlights in her driveway and then noticed an individual standing on the hillside to the south of the house, looking at the house. Suzanne called 911 for assistance in an ongoing urgent situation, someone scoping out her home. The call ended when she learned it was the defendant. The intent of Suzanne's call was not to report the facts of a past crime. Rather, Suzanne was describing current circumstances requiring police or medical assistance. Those statements are not testimonial. And then it cites People v. Harris and Davis and People v. Welsh, recognizing the applicability of Davis to the analysis of statements made on a 911 call in Colorado. Thus, the statements are admissible if the statements constitute a hearsay exception. CRE 807. Based on the above, the people respectfully request that the Honorable Court deny the defendant's motion. And then,
You run that.
and then Barry's Peeps responded. Reply. Motion to exclude out of court statements attributed to Suzanne Morphew. Mr. Morphew provides the following reply to the prosecution's response to his motion to preclude out of court statements attributable to Suzanne Morphew. 1. The prosecution addresses only one specific statement, a call made to law enforcement in November of 2018. Further, the prosecution addresses only the constitutional issue whether admission of the call would violate the confrontational clause while addressing the hearsay issue. 2. On the confrontation clause issue, the prosecution concedes that statements to law enforcement are generally regarded as testimonial hearsay and therefore are not admissible pursuant to the confrontation clause of the state and federal constitutions. The prosecution claims an exception from that rule based on Davis v. Washington, in a Colorado case that cites Davis. I have thoughts. We'll get to those though. 911 calls, however, are not automatically excludable. Whether a 911 call is testimonial must be decided on a case-by-case basis. Here, the prosecution does not present the call or its contents to this court so it can decide whether or not the statements are testimonial. In Walsh, the unpublished case, the prosecution cites people in Harris, blah, blah, blah. The court reviewed the call before issuing any ruling. In Walsh, the trial court excluded the 911 call. In Harris, the trial court admitted it. Further, the prosecution addresses only the constitutional issue, whether admission of the call would violate the confrontational clause, while addressing the hearsay issue. The prosecution makes no claim that the call satisfies a hearsay exception. Okay, I'm going to speak my thoughts before I finish this page because I don't want to just go back and be like, anyway, they are stating something that is not true. We just read the prosecution's response. The prosecution did not even say that this was here. They did not even say what they're saying here. They said that this is the closest to something that could be considered testimonial, but they said it is not. Anyway, the prosecutor states that the call will be included in his notice of proposed CRE 404B evidence. Thus, Mr. Morphew does not discuss admissibility issues in this motion to preclude hearsay. He notes, however, that the events surrounding the call and the call itself will fail to satisfy CRE 401, 402, and 404 and would violate CRE 403 if admitted. The prosecution urges this court to not rule on the motion because the defense has not identified the out-of-court statements the prosecution may seek to introduce. That turns the burdens upside down. The prosecution should not be allowed to talk about unadjudicated hearsay statements in opening statements and should not be allowed to introduce said statements without approaching the bench and explaining why it believes the statement are not hearsay and why the confrontational clause does not bar admission of the statement. This motion in limine must be decided pre-trial to prevent mention of the information and information derived from it in remarks or questions to prospective jurors or in the prosecution's opening statement. The damage will be done long before the prosecution even calls the witness to the stand. This motion in limine must be decided pre-trial to prevent the prejudice that would ensue from the prosecution presenting a witness starting to question that witness about hearsay and then forcing the defense to object in front of the jury. The jury would certainly view this as if the defense were trying to hide something. The prosecution should have to approach the bench beforehand so that the dispute is resolved outside the presence of the jury. Wherefore, Mr. Morphew respectfully requests that the court exclude from trial for any purpose Suzanne Morphew's out-of-court statements and prohibit mention of any such statements in voir dire, opening or closing statements, and testimony. So, Barry is trying, once again, to put one out there trying to make sure that Suzanne's words, her voice, are silenced, and the prosecution is saying we are going to use this and there are reasons to be able to use this and they are covered under hearsay and such that they can be used because Suzanne is not here to testify on her own behalf. And that is something that is going to be very heavily argued, I think, during this next week That is something that Barry very much doesn't want out there. He wants all evidence of Suzanne gone. He wants her voice gone. Um, and I sure hope that it comes out, after the motions hearing at whatever point when the paperwork comes out. I hope that the order is that that defense is, that defense motion is denied. And so now we open the question and answer portion. Please like and subscribe and hype this video. When this goes to be, like, for the replay crew, I'm going to put in the timestamps of where all of this went down. And Penny mentions, I bet Barry does want to exclude the police testimony. 61 interviews, holy moly. Yeah, he's got over 50 hours of him blabbing on to cops.
And remember, whatever he says will be used against him.
And Sarah Jacobson says, I'm just saying the argument that the defense could make about banning police uniforms as intimidation or being influential. And but I think that they can't really say that if a cop is on active duty and gets hauled in there to talk, they can't just, like, make them not wear their uniform. But I think that, anybody that's off duty should probably appear in a suit, even though they're going to identify themselves as officers. And Deborah says, sounds like there's some straw grasping going on, and I believe so. And Sarah, I see that I see your point about police testimony is fine, but visual uniforms in a court can be debated as influencing the jury. But if he does a blanket thing about their, as it is, he's saying a blanket thing that there could be no uniforms in court, meaning that those court officers that stand in the court, that are there,
like the bailiffs
and stuff, that if it gets passed as a blanket one, like he's saying, that would say no uniforms in court, and that would mean the bailiffs would have to not be wearing uniforms, and the bailiffs are always wearing uniforms. So I think that if he wants no uniforms on the stand, that could probably be worked with, because, like, even if a cop was on duty and got called into court, I'm sure the prosecution could have made arrangements to where he could change his clothes into clothes that he had prearranged to have there, maybe outside of court, maybe. But just a blanket say no uniforms in the courtroom.
That's not very well worded by prosecution.
No, by the defense. No, it's not, because saying no uniforms in the courtroom at all.
Well, the judge.
That's like.
Now what?
Well, the judge robes.
He's a uniform as well. You know who doesn't wear a uniform? Is the girl that takes notes.
And Sarah's saying the same thing about, only police related to Barry's case should be told not to wear uniforms, and the bailiffs should have their uniforms, and because they're always there. And that's just the issue, is that Barry's defense lawyers are not, they're not, and I think it's on purpose, that they're not clarifying, and they're making these blanket motions that take up time, because I'm sure that the prosecution would agree too that if it was worded in such a way as saying, I would prefer there not to be somebody in uniform on the witness stand, that would be a different thing than saying no police uniforms or insignia in the courtroom.
How does a powerful super lawyer like that make that mistake?
And I don't think it's a mistake on their part. I think that they are stalling. What do you guys think? Do you think there is stalling going on? Do you think that Barry's team are purposely making all these blank statement motions that don't have any citations, anything to back them up, and just being thrown out there in order to cause there to be lots of just make there be so much paperwork in that, because part of this, the whole pile of documentation that happened, that was part of the reason that the defense used to say, okay, we're not going to be ready because we have to go through all this paperwork, and half the paperwork they created themselves. And they're saying, well, we haven't been able to go over the evidence that the prosecution has given us because we've been going through our motions and stuff, and so we haven't had time to read or go through the evidence that we have. And it's just like,
Well, the last time we talked about this, counsel said we are not prepared to represent this man.
And
how was that worded?
In case
Do you
you didn't-
remember?
they said that they were not prepared to provide an adequate defense for Barry,
And this would
and
lead
that's
to a
which would lead to an appeal, if and so that's how come the trial is out there in the future, is because Barry's attorneys say that they cannot provide an adequate defense at this point in time, and we all know that the accused, it has the right to an adequate defense, and that if the accused goes to trial and doesn't have an adequate defense, that is an automatic appeal right there. But also, any conviction of something as serious as murder is up for appeal automatically. They're allowed to appeal appeal their sentencing and stuff.
although it was a good way for the council to extend the time
Yeah, and it
by
was
making that very statement.
by using that word, we can't adequately defend him. That automatically pushed back the trial, and what happened with that was the prosecution then said, okay, well, how about January of 2027, which is pushing it back a few months from October, because the trial was originally for the month of October, and then the defense said, no, we're no way going to be able to adequately defend him in January. And then the judge asked, well, when do you think you would be able to adequately defend him? And the defense attorneys said, not until May at least. And then the judge was like, And then he goes, well, the trial needs to be set by July, and I think it's by July 26th, and so
with that one phrase, they got a whole year.
yeah, with that one phrase, the defense got a whole year extension before he goes to trial, and which buys Barry another year of not being locked up, being on basically house arrest, but he's allowed to leave for work purposes, he's allowed to leave for medical visits, and he's allowed to leave to confer with his attorneys.
Remember the judge says you seem to work just fine from behind bars.
Yeah.
Remember that statement?
Originally, the judge was like, you seem to be fine, work from behind bars, and then somehow that bail got set to where it was something that was obtainable, where it was a surety bond, where he only needs to raise $300,000 of the $3 million bond, and he of course was able to raise that because he's been hiding assets all over the place. It just took him a while to get them back to where he had access to them, and it kind of sickens me that he is going to spend another year not being locked up. Is it bad of me that I am hoping that he violates the terms and ends up being locked up awaiting trial? Is it bad of me to wish that? Because that's what I wish. What do you guys feel about that? And DJ says, yes, absolutely stalling. Barry will spend his last holidays outside of a jail cell. Yeah, that sickens me too. And, and then when you just think of Suzanne's family, her siblings, they, at first they must have been devastated that it got pushed back so much. But, and they had already made their travel arrangements and, everything to be here for the trial, to be here and be able to face Barry and see all the evidence and just have everything unfold and get justice for their sister, and now they have to wait. But I'm sure that they have been by now I'm sure they are resigned to this, and by now I'm sure they don't want. Jack gave me a note. But anyway, I'm sure
Yes,
that they
drink some water. It's only been 2 hours.
And anyway, DJ says that they heard that he hasn't been checking in like he's supposed to.
Really?
And I hope,
Dude, that sounds like a violation.
I hope that's the case. And yeah, Deborah, it does seem like what they're saying by not saying it is that he's indefensible. And yeah, they are having a hard time with
That's a
saying how
monster
he's
statement.
innocent, because saying that they cannot adequately defend him at this point in time. Yeah, I would say that another way of interpreting that is that they can't defend him, but at some point they're gonna have to, and just do their darndest, do their best, because that is what the accused is entitled to, is the best defense he can get. And yeah, it's because he's not innocent. And that's the thing is, I actually listened to an interview, interpreted it, that this attorney of Barry's, the lead one, Jane, she was saying, she's actually a very famous attorney, has, world renown. She has worked for advocacy things to get people that were wrongfully accused back out of jail and stuff like that. And anyway, she signed up the Innocence Project. Yeah, that's what she was. And so she volunteered early on, before Suzanne's remains were found. She volunteered to defend Barry. Fireworks. And
Gunshots.
fireworks, you can hear the sizzle. Anyway, then she just has dug in her heels, but she has said that she's a good attorney, and that what allows her to sleep at night is that she gives her clients the best defense they could possibly have, and it does not matter to her whether they are guilty or innocent. They get the same amount of energy from her. They get the same drive. They get the same, trying to get them off. And she says that, it doesn't bother her at all if she knows that she's got a murderer free on the streets, because she has upheld her oath as an attorney for the accused.
Yeah, like they were saying earlier, the lawyer's got a lawyer.
Yep, a lawyer's got a lawyer.
I think it was.
So, so any other questions or anything, or are we gonna call it a night and celebrate the weekend? Let's see. I'll wait a moment for anything, and then I'll go ahead and sign off. I know that was a lot to deal with. 2 hours of documents, you guys, and then all week next week, beginning at 9.
And you
every
think
day
the
needs
trial
be
is
in
going
court.
to take 30 days?
And the trial is supposed to take about 30 days. Yeah.
It would seem with what we just
And
did tonight.
it might be longer
Yeah.
with everything that they have and everything that's be going on. Hi, Shelby. So I guess that's it for tonight. Thank you all for being here, and I will put timestamps in once this is all processed and everything by YouTube, and I'm able to do that. So good night, and see you in the next video. That was Jack's finger.